Hello everybody. Bonjour tout le monde. Je vais juste faire une vidéo en anglais tout court, qui est très important. Je vais revenir en français. So, anyways, the reason why we're doing this today is because we want to congratulate everybody who are doing the human chain across Canada and at the Parliament. And this year is for them, so that everybody knows what we've been up to at the Canadian People's Union, so that everyone can know their rights and enforce those rights. So this is a very important Canadian public broadcast announcement in regards to our rights under our political and civil rights at the international level, as well as well, we don't have very many of those rights in Canada. But anyways, the international level, we do have one. So this is about a letter that we've sent to the United Kingdom and yesterday. So 639 MPs received it. It's also on its way to the Queen, and Boris Johnson got his yesterday. So and all the parliamentarians and how can I say, it's been a long time coming. This has been 13 years for us, and it feels really good because you need to listen very carefully. This is for all Canadians and for our future, and all other countries can do this. So what I'm going to do is I'm going to share the screen so that you can see exactly where we're going with this, and you'll be able to read along. This is going to be able to help all of the visually and hearing impaired people. So please bear with us. And we're going to share now. Then there we go. This is our website. If you go to thepowershift.ca, this is what you'll see. And you'll see our country, our responsibility. Nothing in law supersedes the will of the people. And never forget this. You are richer and more powerful than you know. Okay? Now, this is a official request that was sent to the UK for a constitutional correction. Normally, that would come only from the federal government at the request of the federal government, but we're going to be proving within this document that the Canadian citizens also have the right to request that, and we've been working actually since 2014 to implement this and get some signatures. And we'd like to thank the people from the convoy who have shown the rest of the world how Canadians feel about our governance. So that makes it a lot easier for us. So I'm going to be showing you this document. This is the letter, and I'll just bring it up here. And I'm going to minimize this so that you can read better at the same time as I'm going to be reading this for those who are visually impaired. Okay. So if you go to our website, you'll be able to find the letter and all of the attachments that go with that. So it should be very interesting. Now, here it is. Now, this is regarding the Canada Act 1982, corrections and formal proclamation. Please accept our respectful request for assistance for final corrections to the Canada Act 1982, stemming from the Canadian government failing to meet its obligations to the people of Canada by 1997. Given that the Imperial Parliament of the United Kingdom still has policy responsibility over the Canada Act 1982, as it received royal assent within the Imperial Parliament and is still in force within your legislature. We further request a formal proclamation regarding these corrections as soon as possible to save our country and to restore peace, order, and good governance. This is March 3rd, 2022, and it was sent to the United Kingdom, UK Imperial Parliament by fax, email, or bailiff. The bailiffs will be working all next week too to keep serving the papers in the UK. So here, Her Majesty the Queen at Buckingham Palace, and the Right Honourable Boris Johnson, MP, and the Right Honourable Elizabeth Truss, MP, who is the Secretary of State for Foreign, Commonwealth and Development Affairs, and to the Supreme Court of the United Kingdom, as well as to parliamentary members of Her Majesty's government. They've already received theirs, the Privy Council of the United Kingdom, and the House of Lords. So, Your Majesty the Queen, Prime Minister Boris Johnson, Secretary of State for Foreign, Commonwealth and Development Affairs Elizabeth Truss, parliamentary members of Her Majesty's government, the Privy Council of the United Kingdom, House of Lords, members of the Supreme Court of the United Kingdom. We, the Canadian People's Political and Civil Rights Union, would like to apprise you of what transpired in Canada in 1931, 1960, and 1982. The Imperial Parliament had and still owes a responsibility to the Canadian citizens and Indigenous peoples of Canada whose collective voice was excluded by the Canadian government from having an active role in self-determination in their own governance in the Canada Constitution 1867, 1982, or Canada Act 1982, the Constitution. So I'm seeing here that this is pretty much down there. The International Covenant on Civil and Political Rights was adopted by the United Nations General Assembly on December 16, 1966. Canada acceded to the Covenant on May 19, 1976, as did the United Kingdom. The Canadian citizens and the Indigenous peoples of Canada are the de facto employer of all levels of government in Canada, in that it is by our authority that the Canadian government holds its decision-making power in legislature. Nevertheless, we have been consistently oppressed and not recognized as the de facto employer of the Canadian government, which does not listen to, respect, or work with our collective voice at any time outside of elections unless politically motivated or lobbied to do so. We, the supposed independent masters of our country, have remained the serfs without legal recourse. This issue is not merely about Prime Minister Justin Trudeau, his government, senators, parliamentarians, and all levels of provincial government arbitrarily passing unconscionable laws, notably within the last 4 years, whereby our rights and freedoms have been expunged, but specifically pertaining with respect to the decisions made to derogate from the United Nations International Covenant on Civil and Political Rights. His latest affront being the invocation of the Emergencies Act in 2022, which he tried to pass into law. In addition, the Canadian judicial system also fails its citizens, wherein justices are seen to turn the rule of law into opinion pieces issued as rulings, as shown during the COVID-19 outbreak and thereafter. This, in of itself, is repugnant to the rule of law. Justices have even gone so far as to issue demands for psychiatric evaluation of lawyers whose legal opinions differed from theirs. After many attempts to remind Justice Minister and Attorney General David Lametti, parliamentarians, provincial legislatures, the Governor General, the Treasury Board, the Senators, and the Ethics and Privacy Commissioners of their derogation from both the Charter of Rights and Freedoms and the International Covenant on Political and Civil Rights, they continued their assault on the citizens' rights. As you are well aware that all Canadian citizens and Indigenous peoples collectively possess the political and civil right to self-determination, we wish to invoke those rights within our governing structure immediately, before any more damage is done to our people and country by those who have infiltrated our government through elections, transferring the country's resources to a global governance strategy known as the Great Reset, without the people's informed consent. Now, this is probably the most important paragraph here, so I will reread it. So we're addressing the Parliament, the United Kingdom Parliament. As you are well aware that all Canadian citizens and Indigenous peoples collectively possess the political and civil right to self-determination, we wish to invoke those rights within our governing structure immediately, before any more damage is done to our people and our country by those who have infiltrated our government through elections, transferring the country's resources to a global governance strategy known as the Great Reset, without the people's informed consent. In 1931, the United Kingdom granted Canadian citizens and Indigenous peoples the right to self-determination through free and sovereign independence. However, the government refused to recognize the sovereign prerogative rights of its people. The Canada Act 1982 is still in force in the UK Parliament. Although renamed in Canada as the Canada Constitution Act 1867-1982, the federal and provincial governments have been using it with their own constitutions and Supreme Court rulings as playbooks to circumvent the rights of Canadian citizens and Indigenous peoples. By means of such constitutional conventions, the government seized the head of state powers granted to us in our Constitution without our full knowledge or consent. When looking at the grand scheme of things, it is evident that a corporate coup d'etat has been surreptitiously implemented not only within our country, but by our very own governments since 1931, but also globally. The Canadian government went so far as to use His Majesty the King and Her Majesty the Queen to circumvent their authority in Parliament through the Governor General, but not fully allowing the people a true voice in the decision-making process. As long as the Canadian federal and provincial governments hold final decision-making authority, with no accountability, this country and its people will never be free or protected from the tyranny and oppression that we, the people of Canada, have witnessed as victims to this day. Consequently, our purpose and mandate are, once and for all, to place Canadian citizens and the Indigenous peoples of Canada collectively in our lawful place within the Canadian Constitution, above the Crown of Canada. Moreover, our rights encompass those of the collective sovereigns to inherit the royal prerogative. Prime Ministers William Lyon Mackenzie King and Pierre Elliott Trudeau, together with the provincial premiers, have deliberately denied us our collective rights since 1931 and excluded us from our rightful position within the provisions of the Canada Act 1982 and the Canadian Constitution Act 1867-1982. The arrogance displayed by all levels of our government's totalitarian overreach needs to end now. Therefore, we are asserting our lawful and legal rights, not only through corrections that were omitted from the Statute of Westminster 1931 and the implementation of the Canada Act 1982, but also through the international instruments that Canada has signed, which form an integral part of customary international law to which Canada must adhere. In the past 45 days, we have witnessed convoy supporters from across the country, along with millions of Canadians who are ready and willing to effectuate fundamental changes as to how the Canadian citizens and the Indigenous peoples are to govern our country with our elected governments in mutual respect and integrity. Rather than meeting with the people, the government, the House of Commons, unlawfully invoked the National Emergencies Act against Canadians standing up for our rights. By doing so, the Canadian government had suddenly transformed freedom-fighting, peaceful citizens that were only defending the political and civil rights of all Canadians as branded terrorists and insurrectionists, some being held as political prisoners. Even though the government revoked its decree within days, it continues to inflict its wrath upon the people and our country by seizing supporters' bank accounts without warrants and canceling the truckers' insurance. Obviously, Prime Minister Justin Trudeau, Finance Minister Chrystia Freeland, and Minister of Justice David Lametti have neglected to read the Emergencies Act preamble, recognizing the international law on political and civil rights, which also includes the right to non-derogation of those rights during a pandemic or war. The Emergencies Act 1985, an act to authorize the taking of special temporary measures to ensure safety and security during national emergencies and to amend other acts in consequence thereof. 1988, C-29, assented to the 21st of July, 1988. Preamble. Whereas the safety and security of the individual, the protection of the values of the body politic, and the preservation of the sovereignty, security, and territorial integrity of the state are fundamental obligations of government. And whereas the fulfillment of those obligations in Canada may be seriously threatened by a national emergency, and In order to ensure safety and security during such an emergency, the Governor and Council should be authorized, subject to the supervision of Parliament, to take special temporary measures that may not be appropriate in normal times. Whereas, this is the most important one, the Governor and Council, in taking such special temporary measures, would be subject to the Canadian Charter of Rights and Freedoms and the Canadian Bill of Rights, and must have regard to the International Covenant on Civil and Political Rights, particularly with respect to those fundamental rights that are not to be limited or abridged, even in a national emergency. So, this is serious and deliberate. Now, the convoy and its millions of Canadian supporters across Canada should serve as a reminder for our governing bodies that neither Canadians nor its Indigenous peoples are to be ignored. By invoking our collective political and civil rights, our government will no longer hold the political power bestowed upon it at elections as the ultimate ruler of our country without accountability. The political power belongs to all Canadian citizens and Indigenous peoples. The same must be said of the collective rights of the Indigenous peoples regarding their governance. Canadian citizens and the Indigenous peoples of Canada are equal partners within Canada. Neither one prevails over the other. Our governing bodies should have included us in the final decision makers through referenda affecting major issues concerning our country and its governance on each side of the Truro Wampum Treaty of 1613 and the Royal Proclamation 1763. Our mandate is not to destroy our governance or governments. It is about enforcing our lawful and legal collective political and civil rights over our governance. We as Canadian citizens are willing and ready to legally move forward to invoke this much needed change. Assertion of our collective political and civil rights demands the protection of said rights to our country and its resources for our and future generations. Our society is undergoing a profound restructuring, not least of which is a transhumanist agenda. This is being enacted without our full knowledge or informed consent, which is a conflagration against our own laws and criminal code. Unbeknownst to most Canadians, the lobbyists whose main purpose is to eliminate our rights and freedoms, thereby destroying the Constitution itself, have participated in the Great Reset agenda of the World Economic Forum. By installing themselves within our political party system of governance, including the establishment in 2008 of the Global Parliament of Mayors. The World Economic Forum, with Chrystia Freeland, Canada's Minister of Finance, sitting on its board of trustees, has infiltrated more than 100 countries. The World Economic Forum's business transactions do not only include public-private partnerships, lobbying, and international trade. This is a final coup d'etat against our resources, our country, and our sovereignty as a whole. The aftermath of what has transpired in the past 6 years, or even since 1982, is criminal. In other countries, safeguards have been implemented providing for the arrest of those involved in the usurping of citizens' civil and political rights. However, our federal and provincial governments over time have striven to guarantee themselves immunity from prosecution for their actions. This too needs to end now. Canadians have options to permanently eradicate the corruption within our government once and for all. Revoke the political power held by those elected, and to change Section 9 of the Constitution entitled Declaration of Executive Power in the Queen, to be transferred directly to the collective Canadian citizens and Indigenous peoples immediately, or as soon as humanly possible, since the Constitution and the Crown Corporation belong to the Canadian citizens and the Indigenous peoples, and not to the government itself. This demand is our right, and one that we will be officially implementing from this day forward, as this is how it should have always been and can be in light of the latest coup d'etat by the Trudeau Liberal government. Canada, with all its assets and governance, belongs to the people. Our purpose is not to destroy, but to enhance and protect our country from those who seek to rape and pillage its resources. Therefore, we ask of the United Kingdom Imperial Government to implement the necessary modifications to the Canada Act 1982 to reflect the changes required by placing the prerogative and executive final decision-making authority upon the collective peoples of Canada, with all decisions to be made through referenda. We thought it necessary to request these modifications as our Constitution is still in force in your legislature. We are aware that whereas our government had not fulfilled all of its requirements, and since it is held within your legislature, then it is still in full force and effect, and the final ties to the United Kingdom still remain and have not been spent to this day. UK Parliament Hansard Legislation, Volume 447, debated on May 12th and on Monday, the 12th of June 2006, in regards to the Canada Act. The Foreign and Commonwealth Office has policy responsibility for the following acts or parts thereof, which remain in force and which received royal assent between 1976 and 2006. Some of these acts contain provisions which appear to be spent. A definitive list of all parts of the acts in the relevant period for which the department has responsibility could not be provided without incurring disproportionate costs, and that is in the UK Hansard. UK Law Commission Statute Law Repeals Consultant Paper states, candidates for repeal are selected on the basis that they are no longer of practical utility. Usually this is because they no longer have any legal effect on technical grounds because they are spent, unnecessary, or obsolete. But sometimes they are selected because although they strictly speaking continue to have legal effect, the purpose for which they were enacted either no longer exists or are nowadays being met by some other means. So if the Canada Act 1982 is still in the UK Constitution, it's because things are not finalized and it's still in full force and effect in the UK. Statute Law Repeals of the Law Commission, a review of our work, state that what has been repealed as a result of our statute law repeals work since the Law Commission started in 1965. The following pages set out some of the more interesting repeals. To give an historical flavor that are grouped according to the reign in which they were originally passed by Parliament, the repeals were sometimes because the statutes in question had become obsolete, having done their work, but many repeals were because the act had become superseded by later legislation. So the repeal of an act banning or allowing a particular activity did not necessarily mean that the activity was thereafter made legal or illegal. Often it just meant that the act was no longer needed because the activity in question was banned or allowed, but by more recent legislation. If you continue reading, it will also state that any further if an act is not repealed, that is the one that is still in force and effect, even though others prevail or have been added on after. But the ones that are still there are still in full force and effect, even though other laws would have superseded that. Therefore, the problem still relies or still is in the hands of the United Kingdom to place the Canadian citizens in our rightful place along with the Indigenous nations. So we are also aware that the United Kingdom's priorities have been to Canada and its people as a whole, and not to the federal or provincial governments, evidenced by the drafting of the Statute of Westminster in 1931, and again with the Canada Act 1982 in the minutes of the UK Hansards, the Kershaw Report, and the Imperial Conferences of 1926 to 1931. History of events. Unfortunately, inasmuch as the United Kingdom committees tried to ensure that Canadian citizens and Indigenous peoples would be protected, they faltered when they chose to only follow colonial constitutional practice with regard to the Canada Act 1982, neglecting our collective political and civil rights. The transfer of the Canadian Constitution from the United Kingdom to Canadian responsibility was not done in consideration of Canadian citizens and Indigenous peoples, but in light of the continued colonialism embodied through the sovereignty and prerogative power of Parliament. and the Queen. This power was given to the government over Canadian citizens and Indigenous peoples, international law, collective self-determination rights within the United Nations declarations on the granting of independence to colonial countries and peoples in 1960. So the government took our power for themselves. That is a coup d'etat. This matter was debated and recorded in the Hansards. It was at the time and always will be within the collective's political and civil rights in its entirety, enabling us to choose our own system of governance democratically. The United Kingdom, the Canadian government, and the Supreme Court of Canada were all aware of the Canadian citizens and Indigenous peoples' collective rights through decolonization and self-determination from a colonial system of governance. The Canadian government and Senate purposely failed to mention these facts in the Canada Bill, now Canada Act 1982, renamed the Canada Constitution Act 1867-1982. These facts were further omitted from the Kershaw Report. Through patriation of the Canada Act 1982 and the Charter of Rights and Freedoms, the Canadian government purposely disregarded the political and civil rights and the rights of decolonization and self-determination of the Canadian citizens and the Indigenous peoples. The Canada Act 1982 was the catalyst that allowed the current Prime Minister, Justin Trudeau, Pierre Elliott Trudeau's son, to bring about the third coup d'etat, whereby he, his government, and political party, as well as all parliamentarians, senators, provincial premiers, mayors, and band council members, set about to divest us of our rights, freedoms, natural resources, and our country through the World Economic Forum agenda, leaving us without lawful recourse to protect what has not already been stolen by corporate greed. The people were once again denied their true freedom to invoke their collective rights to self-determination and self-governance. No sovereign, governor general, or government has the right to rule over the people's will. As is being perpetrated in Canada, that should be up to the people to determine. Justifying a government's decision to implement a certain matter should not be based solely on a simple survey or poll, say, of 1,500 to 2,000 participants out of almost 38 million inhabitants, because that would not be fair representation and inaccurately states that the majority of Canadians agree. It's based on fraud, added by myself. By governing based on political precedents instead of law, the Canadian government is not acting according to the will of the people, but to that of a colonial system of governance. By law, the government would have to hold referenda before decision-making can be undertaken, although the imperial conferences did clearly state in the King's Oath and recited by Mackenzie King that the people were above government and directly under him. And that was under a colonial system. The position may be summed up in the words of Mackenzie King. Particularly significant was the new form of the oath by which the King solemnly declared the sense in which he has accepted the crown. From the first time South Africa, New Zealand, Australia, Canada are expressly named. His Majesty thus records that sovereignty is to be exercised in the interest of the peoples of Canada and the other countries set forth, according to their own laws and customs. For the first time in this great ceremony, it was recognized that the relationship between the King and his people of Canada is direct and immediate. The oath has long embodied the principles upon which our system of democratic governance is built. It now recognizes that the relationship of the several peoples under the crown, one with another, as well as with foreign states, have become interpenetrated by the ancient principles of freedom and the rule of law. Emphasis added. So everything was based on freedom. It didn't mean that Mackenzie King could usurp the Canadian citizens' rights and the Indigenous peoples. Thus, it may be said that the new oath, preserving the old and finding place for the new, embodies a simple fashion of political faith and mirrors the structure of this group of free, equal, and autonomous states known as the British Commonwealth of Nations. After World War II, the Covenant on Decolonization opened the door to self-determination in 1960. It can be proven through international law and the imperial conferences that the people still remain above the government to intervene whenever we collectively choose. Self-determination is constant. It is not to be used and discarded only through each federal or provincial election. However, the Canadian provincial governments made certain that we would not have legal recourse to do so. The Kershaw Report, Section 80 states, in part, ministerial warnings against the impropriety of questioning at Westminster any federal proposals seem to overlook the distinction between questioning Canada's sovereignty as a state and taking into account the limited legislative sovereignty of its federal parliament. No one doubts that the federal government represents and speaks for Canada in its external relations and foreign policy. But in the matter of constitutional legislation, there is a limitation placed on the plenitude of its authority to act, placed on it not by the United Kingdom, but by the people and the Constitution of Canada. Kershaw Report, Section 85 states, nothing in our report casts any doubt on Canada's full independence as a sovereign state in the international legal and political order. In 1931, when Canada was becoming a sovereign and independent state, the governments of Canada and its provinces agreed that the power to amend the BNA Act should remain with the UK Parliament. The Government and Parliament of Canada, with the concurrence of the provinces, requested the UK Parliament to enact a special provision of the Statute of Westminster, Section 7, Paragraph 1. The whole point of this special provision was to remove the BNA Acts from the scope of the power then being conferred by Sections 2 and 7.2 on the Canadian Parliament and the provincial legislatures, viz. The power to override UK statutes. Thus, responsibility for amending the BNA Acts was retained by the UK Parliament at the express and explicit wish of all the appropriate Canadian authorities. That responsibility has been exercised since then on 9 occasions. There was, in 1931, no suggestion that the responsibility was to be retained on condition that it be exercised in any manner other than the manner in which it had been exercised prior to 1931. And this relates to provincial rights to the UK, and they have none. However, this is not precise, since the decolonization of all colonial peoples, colonies, and Indigenous peoples did affect the parliamentary sovereignty of the Crown of Canada. So what I've read before, it's in regards to how they were to do the process, and they based it all on colonialism. But we already had the rights in 1982 to self-determination. So this is why we put this in. However, this is not precise, since the decolonization of all colonial peoples, colonies, and Indigenous peoples did affect the parliamentary sovereignty of the Crown of Canada. The people should have been made the collective sovereigns, holding prerogative and executive powers to delegate. And this is back in 1982. Okay, 1981, 1982. And that's what should have happened, and it didn't. If this has been done as it ought to have been, the governments of Canada would be in their rightful place as public servants of the people to rule for them and not over or against them. Parliamentary sovereignty is only gained through the people and controlled by them as to how the Parliament would continue to manage itself. Kershaw Report, Section 96 states, in part, the Canadian Parliament is not absolutely sovereign, but is, by the will of the Canadian community, confirmed in 1931. Subject to the constraints of a federal constitution, it would not be in accord with the established constitutional position for the UK government and Parliament to consider themselves constitutionally bound to accept unconditionally the constitutional validity of every request coming from the Canadian Parliament. And that's because we would have needed referendums and not just the federal government asking for certain things to be done, but they did so 9 times. Now, the Kershaw Report, Section 103 states, In our opinion, if the UK authorities must be said to have a duty to someone, it would be a duty or responsibility to the Canadian people or community as a federally structured community which has left its ultimate legal constituent powers in the hands of the UK legislature. Still in force in effect to this day, March 5th, 2022. Kershaw Report 110 states, we think that if the UK Parliament is to take into account the clearly expressed wish of Canada as a whole, the approval of the majority of voters in a province could properly be regarded as satisfying the wish of that province for that purpose, and not just because a premier says so. Kershaw Report Section 113 states, it is simply the responsibility of exercising the UK Parliament's residual powers in a manner consistent with the federal character of Canada's constitutional system. Inasmuch as the federal character affects the way in which the wishes of Canada on the subject of constitutional change are to be expressed, it would be quite improper for the UK Parliament to deliberate about the suitability of requested amendments or methods of patriation, or about the effects of those amendments on the welfare of Canada or any of its communities or peoples. Why? Again, because the people come first, not the federal government or provincial governments. International law before English and Asian courts, finding the judicial role in the separation of powers by Veronica Fickfak, University of Cambridge, United Kingdom. International law is part of our law. It was also explicitly referred to by Lord Denning in Trendex. It follows to my mind inexorably that the rules of international law, as existing from time to time, do form part of our English law. Blackstone claimed that international law forms part of domestic law to the full extent, with the domestic system accepting international law as part of the same legal order. His view appears to have been adopted by Justice Gray in the Paquet Habana case. International law is part of our law. As Justice Shaw, what is immutable is the principle of English law that the law of nations must be applied in the courts in England. Asian Journal of International Law, Volume 3, Issue 2. So you can read all that there. We have the link. Supreme Court of Canada, R. versus Hape, 2007. The English tradition follows an adoptionist approach to the reception of customary international law. Prohibitive rules of international custom may be incorporated directly into domestic law through the common law without the need for legislative action. According to the doctrine of adoption, the courts may adopt rules of customary international law as common law rules in order to base their decisions upon them, provided there is no valid legislation that clearly conflicts with the customary rule. Unfortunately, voting in our present election system does not guarantee that those elected to government will fulfill their promises. It only serves to advance the rights of those elected to continue their coup d'etat as evidenced since 1931. Advancing the rights of those elected is even more apparent since the 1970s in violation of our rights to collective self-determination. It does not protect our natural resources or stop our governing bodies from growing road, as they have in the past and are presently doing, especially since 2020, by making illegal decrees in support of their Great Reset coup d'etat without our informed consent. Factual quote from our present-day situation in Canada, and I'd like to find, to thank Richard Reich for that. The government did not employ the law during the darkest times of the COVID-19 pandemic, but now brings its wrath upon the truckers. The move represents incredible power being employed in arbitrary fashion, indicating not strength, but weakness in Canadian government authority. By Richard M. Reich II. However, Richard M. Reich it is also about a government overreaching with an unsavory agenda, in blatant breach of our Constitution and sovereign rights, namely the Great Reset coup d'etat. Given the mess within our Constitution and the fraudulent acts perpetrated by past and present Canadian governments to ensure immunity from prosecution or by illegally disallowing our rightful powers, we, Canadian citizens and Indigenous peoples, are presently faced with no other legal recourse than the use of international law to which Canada and the United Kingdom were signatories. We further request a formal proclamation to correct these fraudulent acts as soon as possible to save our country and to restore peace, order, and good governance. By lawfully moving forward, we, the Canadian citizens and Indigenous peoples, as the collective sovereigns, will have greater oversight with legal recourse over our governments surreptitiously selling our country and its resources or revoking our rights by invoking the Great Reset coup d'etat created by the World Economic Forum, or any other form of dictatorship against our peoples by reducing our status from citizen to client in our own country without our informed consent. And this happened in 2017 in the government data that they were providing. There are many more reasons why Canadians and Indigenous peoples are protesting. They too see beyond the Canadian government's interference by paying off and manipulating the media and threatening any professionals who go against their narrative and coup d'etat, including Justin Trudeau's participation in the instigation of a war with Russia without our consent. These reasons and many more are a combination of why we require your assistance and that of the United Kingdom Imperial Parliament so that chaos can be averted. These reasons and many more are, sorry, I guess we're on to the next one. Now, by holding an emergency meeting of the United Kingdom Imperial Parliament, you have the opportunity to rectify the offenses perpetrated on Canadian citizens and Indigenous peoples by placing them as collective head of state with full powers of the prerogative and executive final decision-making authority over and above the present Crown of Canada. Then the United Kingdom will be free to repeal the Canada Act 1982 once the corrections and assent has been given. In the meantime, while awaiting your reply, we will continue to collect legally binding signatures enforcing the collective political and civil rights of both Canadians and Indigenous peoples who signed their Canadian Citizens Convention of Consent form named the Indigenous and Civil Unified Sovereign Enactment, in effect since 2014. Respectfully, Nicole Lebrasseur, CEO, the Canadian People's Union, not-for-profit. At thepowershift.ca, you will be able to find these documents there. And we also CC'd the International Human Rights Organizations, United Nations Human Rights Committees, and the Organization of American States. And for Canada, they'll be receiving their papers this week. At the Supreme Court of Canada, the Prime Minister Justin Trudeau and parliamentarians, the Senate, and the Privy Council of Canada. And then we have the appendix enclosures with links, so you can click on the links here. You'll get to our to the files. And although there are more than that, we just decide to put those in to back what we were saying in the document. So if you go below, you keep going below, then you'll have all of the files here again. Okay. And what you can also look at is our Citizens Convention of Consent. Okay, we've put the Canada Act 1982 enacted, and then it was revised afterwards, and then you have the revision version there. And you will notice that it is still very much in effect, as long as it's in effect in the legislature of the UK, they still retain those rights, even though they said that they will no longer create laws. Well, we're not talking laws. We're talking about rectifying the Constitution itself. So that is still in their power to do so. Because the Canadian government did not fulfill what they were supposed to do up to this day, and it's time that we fulfill it for them the proper way. Okay, and Indigenous, okay, here I'm going to show you the Convention of Consent. Okay, I'm just going to remove this here. Okay, so this is the I accuse. We have it here. And then the Indigenous Civil Unified Sovereign Enactment. This was created in 2014 with the help of a friend of mine. But when I saw that what we needed, I wanted to make sure that we'd be able to move forward with this legally, and it was through the international laws that this was created. And then we found the Power Shift to Freedom, the Power Shift book by Von Lyons, put everything together, and it gives us our Power Shift to Freedom, how we can move on to this without disrupting government, other than maybe jailing those who we'll see who actually were corrupted or did criminal activities. So we're going to have to get people to forensic audits into our governance and everything else, so to see what they've been up to and what they've been doing, and try to reclaim some of the things that we've lost and move on from there, and finally turn taxation into dividends. Is it possible? Let's try. Okay. And yes, it's very much possible. So this is, again, the document. And what you should do is, if you don't know where to start, you go to the powershift.ca, and you'll be able to find all these documents. So this is it, people. This is, I've been waiting for this moment for 13 years. And we needed the people to wake up, but it was hard. And thank goodness to the convoy, to all of those who decided to join in, all of those who decided to support the convoy. Um, it woke up a lot of people to the reality of what's happening in our government, and we stand strong today. And as long as you stand within your legal, political, and civil rights at the international level, and yes, Canada has to recognize as though it's part of our constitution, they can't deny that. Okay, we've covered all those bases, and if other people are still trying to argue it, well, we'll see you in court. Okay, and gladly. And maybe now those who have not listened to us, who kept breaking the laws, will now have to hire their own lawyers to save them. It's time that Canadians stood strong, have faith in our future, that we stay away from chaos, and do it the right way through your citizens' political power, and that's signing your Citizens Convention of Consent at thepowershift.ca. Become a member, sign your Citizens Convention. 15 years and older can sign this. It's their country, their responsibility as well. And Justin Trudeau, thank you for making my day. Thank you for having the notion to pull what you did, because now Canadians and other countries can do the same legally, the right way, without chaos. We just need to get rid of those creating chaos. Okay? So it starts with you and every one of your neighbors. This is not just about us doing all the work. It's about every citizen, making sure that everybody signs their Convention of Consent. You want your rights, you want your freedoms. Let the UK know how you feel. Thank you. Goodbye. Have a great day with thepowershift.ca. Happy birthday.